Go ahead.
All right, we're gonna start off with House Bill 26.
House Bill 26 prohibits a private education lender or private education loan collector from initiating a private education loan collection action unless the lender or collector possesses and introduces into evidence specified documents related to the loan. Similarly, they must provide specified documentation in the first collection communication with the borrower and upon request of the borrower. The bill also authorizes a person who suffers damages as a result of a creditor's failure to comply with the bill to bring an action against the creditor. Failure to produce the required documents is an unfair, abusive, or deceptive trade practice under the Consumer Protection Act and subject to that act's civil and criminal penalties.
Just in layman's terms, so this applies to, I'm looking at private education loan collectors. So who's in and who's out of this? I take it all the borrowers are kids who have got school loans for college, and then but it doesn't apply to everybody collecting. So who are we limiting?
So it's entities who are trying to collect on a private education loan. So that would be loans that are not made, insured, or guaranteed under the Higher Education Act.
I'm sorry, they're not insured under the Higher Education Act?
Correct. So it's not the federal loans.
Okay, so this is not an area I deal in at all. So we have loans. Some loans are loans under the Higher Education Act, and then we have other loans that are just I go to the bank or I go to somebody and borrow on my own. And that's what this applies to?
I believe so, Senator.
Okay, so we're setting up rules for them because the other people already got, I presume, a set of rules under the federal. If they're getting a federal guarantee loan, they probably have all kind of conditions on that, right?
Correct.
So this is the others, but it says it excludes means it excludes a non-depository institution or trust entity. They're trying to collect on a private education loan. So you're kind of exhausting really quickly my imagination who is included in this. I mean, yeah, I'm just seeing who this applies to. Who are we limiting here?
Mr. Chairman, so my understanding is that groups like the National Collegiate Student Loan Trust, they purchased thousands of these loan accounts that were securitized and bundled. And then when it comes time to collect on them, the companies repeatedly, and I guess this has been well documented in the New York Times did a big piece on this, on the wrong borrower or person who never owed on a student loan. And then because the collection practices are so easily dismissed, when the borrowers can get access to a lawyer, the companies have taken instead to targeting the lawsuits in communities where borrowers don't have access to the lawyers. So my understanding is that this just enhances the court's ability to ensure that the debt is valid before companies have access to aggressive tools like wage garnishment, et cetera. And it doesn't have any opposition because the legitimate collectors can provide the documentation that's required. And it exempts banks and credit unions, and then just to focus on the companies that are the bad actors in this area. So I guess my understanding is, too, that there's a similar law on the books on the consumer that relates to small consumer debts in the Courts and Judicial Proceedings article, and that this is kind of patterned after that. And then private student loans are different than standard consumer debt, and so this is specific to going after the private student debt like this.
It sounds like these guys go and they get like a confessed judgment, like when the student signs for the loan, they sign like a confessed judgment promissory note, and then they're just buying those up and running with them, right?
That's what it sounds like. It's pretty shady.
Okay.
Well, I mean, from the article,
Yeah, I unless we have evidence, I wouldn't try to describe someone who tries to collect a loan as shady. Most loans are there to be repaid. What I find problematic about this is there's just a volume of information that is required to be included in any loan collection action. And some of it just go over the top. For example, a copy of the self-certification form and any other needs analysis conducted by the original creditor before the origination of the loan. I don't see what possible relevance that has to whether the loan is owed or not. There's another one that says copies of all settlement communications made in the immediately preceding 12 months, a record of all collection attempts made in the immediately preceding 12 months. Well, obviously, they weren't successful, which is why the lender is filing the collection case. So some of the stuff is clearly warranted, but it just goes way over the top. And my impression from seeing how far over the top it goes is that it's an attempt to discourage lenders from collecting the loans that they made. And that's just wrong. If it's information that's needed, and the court really needs this information in order to decide whether the money is due and owing, that's one thing. But if it's just trying to put so many obstacles in the way of the lender that the lender can't possibly collect the loan, that's not the way we should go.
Hold it. Hold it. Motion is to hold it. Roll that, because. Go ahead, Senator Castley.
Initially, when Senator West spoke, I thought he was being a little bit too firm on this bill, but honestly, the more I read it, the more I find myself in agreement with him. I don't like these bills or these lenders. I just sort of a bit of a prejudice against them. On the other hand, I don't want to be grossly unfair. When you start, it says, in addition to all the stuff I would expect to be in the lender's file, if applicable, the names of all persons that owned the private education loan after the time of the default and the date of each sale, and a record of all collection attempts made in the preceding 12 months, and a statement by the creditor indicating whether the creditor is willing to renegotiate the terms of the debt. I mean, why would you put that in front of a trial court that, yeah, I'm willing to settle for 50 cents on the dollar? I mean, if you can take me to court, I'm going to push for 100 cents. You only compromise it if you can stay out of court. So, yeah.
I just wanted to say thank you all. Thank you, especially to the staff for the amazing work that it's been a hard year. You've had, it's funny, it's so weird. I mean, watching it on television, and now it's so weird, I didn't actually realize the work. But look, I just want to say thank you for all of here.
Well, Mr. President Ross, I just wanted to say on behalf of the committee, thank you. I know the senator from Montgomery County from District 19 said it best this morning, but you all have done a fantastic job keeping us safe. And the odds-on favors are that we were not going to complete the 90-day session, and we did, and it's because of your leadership. So thank you for keeping us all safe and keeping us functioning so we can continue our work on behalf of the citizens of Maryland. So I just want to say thank you for your leadership and for supporting our committee. Yeah. Senator West, get on.
Before you go, on behalf of Senator Hedelman, I invite you to have a piece of cake.
Oh, thank you.
There you go. See you later. Thank you, Mr. President.
You can have some too. Invite everyone.
I think we don't feel no matter how much we appreciate the open cake.
If we come back here.
I thought he was coming up to commiserate of the abuse that you have to take regularly, though.
Now he understands. All right. All right. All right. So go ahead, Senator Cassidy. You're in the middle of attack.
No, I mean, I got my piece. I think a whole would. I'm very much in favor of the spirit of this bill, but I do have to agree with Senator West that we've gone a bit over, I think, in this bill to the point where it's like, you just can't say, well, we're going to make this so unreasonable for you, you won't ever file. That's kind of is where we're going with this. I think that's not really fair legislation, but I do think it's a good bill. For most of this bill, I support it.
What is the big sticking point? Because I agree with the spirit of the bill too.
So I have no problem with giving people the information they should have. I mean, I should know what my the original loan documents, how much of my payment history, any letters you've sent to me for default, if my guarantors have made any payments on that, I should have all that. I should know the name of the actual lender. You know, that basic information ought to be there. But then we go on. Now we're up to line, let's see, it's 20, 24, 20, 26, God almighty. It's 30, or 20, 21, my Roman, I'm sorry, 21 items. We got 21 categories of documents, which include a statement as to whether or not the lender would be willing to compromise. It was like, who files a claim in court and saying, I'll be willing to take, you know, here's what I'd be willing to settle this for. I mean,
Well, we could just do it like mortgages and make a mandatory mediation.
well, I'm, you know, whatever. I just think it gets to the point here where we're sort of pretending that we're, in the end, the 21 items become so onerous that you're basically saying, don't even try it, sucker. And if that's what we want to do, let's just say, don't even try it, sucker. Let's not pretend that that's not what we're saying, because to some extent it is. That's my only point.
Very briefly, during my legal career, I've filed any number of confessed judgment cases, year after year after year. The rules are very explicit as to what you have to include, what you have to show the court when you're filing for a confessed judgment. A confessed judgment is collecting a debt that the borrower agreed to pay but hasn't paid, and so the lender files the confessed judgment. This just goes so overboard. It's stuff. The number of things you have to file as filing a confessed judgment is limited to what is reasonable and necessary for the court to know. This provides for at least 3 times as much information, and much of it far more onerous. So, the bill has a good idea behind it. I'm happy to support it, but only if what they're asking to be provided to the court is reasonable, and this is not.
My understanding is that these kinds of cases do not get confessed judgments, so clauses. Most student loans don't, and so you have to go after people and to sue them. And the way that I just sent Senator from Baltimore County and a New York Times piece about why this has become so important and abusive is because the lenders are going after people who are most vulnerable and the least, who probably have the most debt and the least tools available to them to fight it. And this is a way of just making sure that the information that they're using is accurate. The judiciary did have some concerns about it. They clarified some amendments. So there seems to be consensus by all of the parties included here that this is the way to go. And there wasn't opposition among them, So I just wanted to make that clear. But this is a pretty abusive practice that this would help to.
Just an example, the last one. The person filing the case has to file an affidavit stating, one, the date on which the private education lender or private education loan collector has a good faith belief that the applicable statute of limitations will expire. Well, the court knows that. There's no need to file an affidavit about that with the collection action. I've been involved in lots of confessed judgment actions and other collection actions in Maryland over the course of my career. We don't have to file that kind of a thing. That's something which the court is well aware of.
This is. I know it.
Makes the debate go away.
So I got two other bills I want to get to here. Do we have any concur or not concurs? Do we have? All right. Let's just run this and see what happens, all right? I know. All right. So the motion's for a favorable. It's been seconded.
Lopez?
Yeah.
No, it was not. It was not.
I just made a motion for favorable. All right. All right. So what do y'all want to do?
Hold it.
Bring it back next year in reasonable form, I'll vote for it.
All right. I tried.
You fought like a tiger.
All right. We're going back to, so we've got some concur, not concurs.
All right, so Senate Bill 888.
Which one is that?
This is Senator Vidal, Anne Arundel County Speed Monitoring Systems. Josh, you have it, 888.
So as passed by the Senate, this bill authorizes the placement of speed cameras in Anne Arundel County on Route 175 between the Maryland Route 175 and 295 interchange and the Anne Arundel County Howard County line, subject to existing signage and placement requirements. The House amendments would require that any fines collected after cost recovery be used for roadway and pedestrian improvements in that area. It would require a real-time display of a driver's speed in proximity to the cameras, and it would terminate after 5 years. Those are the House amendments, yes.
What was the last thing you said?
So the last part was that the bill would terminate after 5 years with the
Okay.
House amendments.
The sponsor wants us to concur, but what do you want?
What route was this, you said? Route 175? I'm just trying to figure out my drive this. The Howard A. No, I take 100.
Yeah, yeah.
I mean,
I'm serious.
I'm gonna vote it anyway, but no.
All right, so the motion's concur. Is everyone okay? All right. Is everyone
All right, hold on. But if you're gonna vote on the final vote, I don't want to be yes on that.
got it?
You don't want to concur? That's the only question is
All right, all right, all
concur.
right.
It's just up or down.
It's just concur, not concur. The next one, Jamie.
Sure. The only thing that the House changed on this was the penalty. Let me just pull this up.
Yes.
Senator Cassidy.
1 year, right? They changed it to? Yeah.
All right. All right, everyone's good. Thank you.
you hear what they did?
So,
They struck the bill and put ghost guns on it. So
That's fine. That's fine. Whatever they did.
That was mine, and it never made it back over.
Well,
I'm
no.
joking.
not exactly, but close. So this bill extends the notice that a landlord must provide certain tenants if the landlord wishes to repossess the property at the expiration of the tenancy. So Senator Waldstreicher offered an amendment on the Senate floor. So the House's amendments are to that specific amendment, which dealt with a landlord who receives notice to foreclose on the property. So under the House's amendments, the language dealing with a landlord who receives notice to foreclose on the property, this is only going to apply, this does not apply in Baltimore City or Montgomery County because they already have similar provisions and they didn't want to touch that. It does not touch or apply to a landlord who offers 5 or more residential dwellings for rent in the state or property that is subject to an order to docket under 7-105.1. So under the new language, if a landlord receives notice of intent to foreclose on the property, the landlord shall provide written notice with the intent to terminate the tenancy. And then it's the same as Senator Waldstreicher's amendment. So instead of a may, it's a shall, and then the exclusions are different.
Just to understand the bill, so this is, I own a building that's got 10 apartments in it, and my building's getting foreclosed on, then I have to give my tenants notice that my building's being foreclosed on? Is that what it's saying?
So since you own 5 or more, this language would not apply to you.
Okay, so, all right, so I have a building with 4 tenants, with 4 rentals in it, and it's being foreclosed, and I have to give this, what this bill says, I have to give them all notice that my building's being foreclosed on, and they'll probably end up losing their apartment.
Yeah, so if the landlord gets the notice to foreclose and the landlord desires to terminate the tenancy to the tenants, the landlord shall provide the written notice. So it's at least 30 days before the expiration of the lease in cases where there was a month-to-month tenancy, or if the tenants had a year-to-year tenancy, it's 60 days.
And who has to give the notice, the landlord or the bank who's foreclosing?
The landlord, if they desire to terminate the tenancy.
Well, he's being foreclosed on. I don't think he really cares. It's the new owner that's going to care about that. I mean, why, if you're foreclosing on my building, you can take it. I don't care. Take my building with the tenants. Why would what do I care if I'm losing the building? You're taking my building and you're going to sell it, and I'm the landlord. I thought that would be the lender that has to give the notice.
Yeah, so the House's amendments, they changed it from a may to a shall.
The point was to make sure that the tenant is on notice that there's a change happening and that could affect their lease. That's what that is about. So, yeah, the lender has to give it to the landlord, but the landlord, it's a courtesy to give it to the tenant.
So it's requiring the landlord to tell the tenant, this is being foreclosed on, you have a new owner.
Yeah,
Right.
What's the problem with that?
I don't have any problem with that, except that the landlord's not going to give it because he doesn't care. The new owner needs to tell them. They're the ones going to be stuck with the tenants, not the old landlord. Whatever.
Stuck
I mean,
with the tenants, or maybe benefiting from the tenants, one or the other.
am I making sense of that? I'm sorry. You're saying that the landlord who's being foreclosed upon has to give the notice.
I think you want to.
So it only says here, so if the landlord receives notice and desires to terminate the tenancy. So I guess you could have the situation where the landlord is being foreclosed on but is not trying to terminate the tenancy of the tenants. So then those tenants would fall under the new owner. So the new owner would notify those tenants that there's a change. But if this is a situation where the current owner is being foreclosed and wants to terminate the tenancy early, there isn't a new owner for those tenants because they're being removed.
That. Okay. Now we'll go to Senator 420.
Not me again.
It's you again.
Oh, you passed all these bills. Oh, me again.
So the Senate had struck the part of the bill that repeals. The House put that back in, so that part would be getting repealed again.
Concur with the House, and let me tell you why. I don't know if you all got emails, because I think they probably emailed everybody, not just me, but the advocates highlighted it, and I can pull it up if necessary, a recent incident that happened since we passed this bill where someone that was obtaining the material for their intimate partner was arrested, and they feel very strongly that sale and distribution pertains to them, those that are authorized to do it. One of the things I would stress to you is, I think somebody in the prior debate mentioned, well, what about, maybe it was Jeff, maybe it was Senator Wallstrike, I'm not talking about for personal use, and I think the bill, and I don't have the bill pulled up right now, but the bill, I think it was somewhere in the bill, the language specifically showed that it pertained to personal use. So for those reasons, I would argue that we should concur. I think they took out the amendment that we put in that was offered by the Vice Chair, because he was concerned about distribution, but I just remind the committee that we already took out, use our imaginations to consider the parade of horribles. If we find out that something went awry, we come back another time and fix it. But for right now, we need to help people not get arrested for trying to seek their treatment.
So concur or not concur? So the motion is to concur.
Vice Chair Waldstraker.
Yes.
Senator Lee.
This is to concur, right?
Yes.
Yes.
Senator Castle.
No.
Senator Hemelman.
Yes.
Senator West.
I don't support the bill, but
Senator Jackson.
Yes.
Senator Bailey.
no.
Yes. Yes.
Motion to concur carries.
I had a letter. I got the same letter. I got a letter, and some people have reached out to me from the Baltimore Harm Reduction Coalition, and I thought it moved me on that. So, all right. What's the
Oh, the grammar one?
grammar? Yes,
On, so, what is it?
there are two of them, but one I know Senator West and Senator Sidnor. It's the Baltimore County thing. We're not. Don't worry.
No.
Although it would good to see you get jacked up on that. That'd be fun. But hold on, let me pull it up.
268, I think.
I know it's fine. Yeah.
Cannot see, I need my computer to put it on the list though, so I can.
House Bill 268.
No. House Bill 268. Yeah.
Yeah, House Bill 268. Dealing with that.
That's the
Spouse can be
spousal.
compelled to testify if they get married right beforehand.
Woo.
Jamie? Yeah.
That's Jamie.
House Bill 268.
It's 121 to 11. This is that a person.
What does it do again?
Well, so the general rule is there are exceptions under existing law. So the exception would be would widen that to situations where the person on trial and the spouse married after the date on which the alleged crime.
Wilson, the Court of Appeals considered the applicability of the spousal testimony privilege, context of a, quote, sham marriage. The court did not ultimately reach the question of whether to judicially establish a categorical sham marriage. The case, defendant in question could be found guilty of witness tampering and obstruction of justice.
Vice Chair Waldstraker.
Yes.
Senator Lee.
This is favorable, right? Yes.
Senator Castle. Senator West.
I love the way Senator Waldstreicher says yes. It's like he's finished a really good meal. I'll go yes.
Senator Sidnor.
I appreciate Senator Huff reading from the court, and I think I like their more narrow interpretation, so I'm going to say no.
Senator Jackson.
No.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
Yes.
Senator Hemelman.
Yes.
Chairman Smith.
I think Senator Sidner has the best laugh in all the assembly, so I'm just going to roll with him because I love the way he says no. No, seriously, my thinking's more in line with what you're saying, so I'll go now.
Bill passes.
Bill passes. All right.
Criminal behavior after you get there.
Which one is that?
268,
Oh, we've got.
conform House Bill 531.
Got it. Yes. Thank you very much for that. Okay. That's Jamie. That's counsel.
So that was handed out,
Sorry.
that actually the amendments to Senate Bill 268, but the idea is that House Bill 531 would be conformed to look like this. Essentially, the only difference between this and what the Senate already passed with 268 is that it adds second-degree sex offense to the lifetime sex offender supervision statute. And yeah, that's the only difference. Now, second-degree sex offense was repealed in 2017 or 2018. So because of ex post facto, this really couldn't be applied to people who'd already been convicted of it. It would only apply prospectively to people who committed the offense prior to the statute being repealed, but were convicted subsequently.
The motion's conformed. The House bill to what the Senate bill did. All right, is everyone okay with that? Excellent. Okay, that's it. See you on the floor.